Why don't we get started? Thanks to all of you for joining us this evening. I'm Trevor Morrison. I'm the Dean at the Law School here at NYU. Um, and we're very glad you could join us for this event this evening, Impeachment, Threats and the Constitutional Challenge, which is being co-hosted by our Reese Center on Law and Security, as well as Just Security here at the Law School. The panelists we've gathered this evening really are about the best possible panel that anyone could gather anywhere on this topic. We're very grateful to all of them for being here. I'm going to give them much shorter introductions than they deserve so that we can get going with the conversation itself. But we are thrilled that all four have been able to join us. Bob Bauer, our professor of practice and distinguished scholar in residence and distinguished senior fellow at the Reese Center, and of course, former White House counsel to President Obama, and counsel to the Obama 2008 and 2012 campaigns, as well as most recently, a senior advisor to the Biden campaign. Ryan Goodman, our Ann and Joel Ehrenkrantz Professor of Law and faculty co-director of the Reese Center, as well as founding co-editor-in-chief of Just Security. Jillian Metzger, our friend and colleague from Uptown, the Harlan Fiske Stone Professor of Constitutional Law at Columbia Law School, where she also co-directs the Center for Constitutional Governance. And Melissa Murray, the Frederick I. and Grace Stokes Professor of Law here at NYU, where she's also the faculty director of the Birnbaum Women's Leadership Network. Thanks to all of you for joining us this evening. So we are on the eve of the second impeachment trial of former President Trump. And there are a lot of important legal issues to address among the many. And we have put together this panel this evening to address those questions. We have about 75 minutes. Before we launch, for those of you hoping to receive CLE credit for this evening, thanks for joining us. And you can get CLE credit for this. And so I need to say some opening things here, and including to make sure that you look out for a code later in the program. So CLE is associated with this event. The process, if you're seeking CLE credit, means that you must pay attention throughout the program. I think you would do that anyway. And look out for any codes that are announced during tonight's discussion. Then soon after the event concludes, you will receive an email link to an attorney affirmation form, which you will be asked to submit. And within that form, you'll have to enter a code that we're going to give you at a later point in this session. And so please be aware that this event is appropriate for both newly admitted and experienced attorneys in New York and has been approved in accordance with the requirements of the New York State Continuing Legal Education Board for 1 credit hour in the areas of professional practice. That credit will be both transitional and non-transitional. Okay, with those preliminaries out of the way, Melissa, let me start with you to help set the stage for us. By just reminding us and making sure we're all on the same page in terms of what has former President Trump been impeached for, what was included in the articles of impeachment, and perhaps what was not included as well, and what should we expect in terms of the basic process of the trial starting tomorrow?
So the article of impeachment is relatively broad, but that is not I should make clear, it's only a single article. The president has been impeached for inciting an insurrection on January 6th. But in building the case or explaining why that insurrection took place and what the president's role in it was, the managers have actually crafted a pretty lengthy narrative. It's about 5 pages altogether, in which they start with the November election. They talk about the post-election landscape in which the president and his subordinates repeatedly raised this question of election fraud. There's discussion of the January call with the Georgia Secretary of State, in which the president implores the Secretary of State to identify and find additional votes in order to secure Georgia's electoral votes for him. There's a discussion of the vice president's role in certifying the Electoral College. And all of this is to relate it to the president's actions at the Ellipsis, where he, in that rally, allegedly exhorts the crowd to take back their country and to stop the Congress from certifying the results of the Electoral College. Again, it's a pretty lengthy narrative, about 5 pages in all. And again, it's breadth, even though it is just about the single count of inciting an insurrection, is one of the defenses that the president actually raises in his answer. The idea that the managers have really lumped together lots of different bits and pieces of conduct, when in fact they could have spread them all out and made them individual articles, or just to charge them individually going forward. And this makes it harder for the Senate to actually pass judgment on them, because they're just sort of massed together in this one single indicting document.
So Bob, what about that? Or is it clear from the article of impeachment what the elements of this alleged high crime and misdemeanor are? Is there just one set of things that 2/3 of the voting senators must agree upon in order to convict, or are there different potential paths they could take?
So I suppose there are, and I'm speaking broadly here because who knows how ultimately the debate will shake out, but there are those who may focus entirely on January 6th and about the former President Trump's appearance at the rally and what he said that constituted incitement, and then address the arguments that Trump's lawyers have made that Trump has an overriding free speech right, and that in any event, this wasn't inciting speech, even if it's analyzed under standard common law principles. So that's one way of looking at it. Another broader way of looking at it is that this was the culmination of what the articles refer to as an ongoing effort, prior efforts to obstruct and subvert the electoral count process. And therefore, it would take into account the entire train of events from November 3rd through January 6th. One example that the articles give, of course, is the call to the Secretary of State that Professor Murray mentioned, in which he exhorts the Secretary of State to find the votes that he needs to go over the top in Georgia. But there are, of course, other circumstances, like calling the state and legislative leaders from Michigan to the White House, calling legislative leaders on the phone, and imploring them to send alternate slates to Washington, D.C., or I think this is very significant to a judgment on Trump's position as a constitutional matter, of the various statements that he made about his expectation of what Vice President Pence would do as the presiding officer in the trial. So I think members could go to January 6th, but they could also see January 6th within this broader attempt to obstruct and subvert.
That's helpful. And what do we know? This is for anyone to jump in on. Do we have a sense of what to expect from the trial? I mean, are there going to be witnesses? Is there any role that any other part of the government might play? What's going to happen starting tomorrow? Anyone have a sense of that? Ryan, go ahead. I think you're muted, though.
Sure. So I think that what we're first going to see is a airing of the different sides' views on the constitutionality of whether or not a former official, a former president, can be impeached. And after that, it'll probably pass by a somewhat bipartisan majority, or there'll be bipartisan majority acceptance of it, as they have already indicated. And then we'll get to the facts. And it sounds like there will be a lot of reliance on video presentation by the House managers, according to reports in the Washington Post and in the New York Times. And there is still this open question as to whether or not they'll call witnesses. It depends on what you've read in the last hour, and that might change. But it sounds like at present they won't, but they might. And then it would go to a vote, it sounds like, if indeed the House managers said they wanted to bring witnesses. And
sorry, what would go to a vote? Whether to call or whether to issue a subpoena that, might be enforceable by a court? What would be the thing that they would be deciding on that?
So it might just be the first threshold question of whether or not to actually just call witnesses, which the Senate would decide. And then if those witnesses are reluctant to come forward, or would only want to come forward under a subpoena, then they would be able to vote for a subpoena. And then, I think just to add a little flavor to it, that's the formal procedure for this, but I do think some of the wild cards are external to the Senate. So are there people who are like whistleblowers that will come to the New York Times on the eve before the impeachment today or tomorrow, as happened with John Bolton in a certain sense, and his book being leaked, part of his book being leaked during the first impeachment trial? And then second, just your question, Trevor, about other parts of the US government, there is another moving part here, which is the Justice Department. And it is conceivable that there'll be developments in some of their cases that bear on the question of the impeachment trial. One issue for sure is that the Department of Justice has already signaled it's very likely they're going to bring seditious conspiracy charges. Whether that happens in the next week or so, not as likely, but it's a wild card that might happen.
Bring those charges not against the person of Trump, but against others involved in the
That's
event.
right. That's right. So, exactly.
Got it. So reference has been made a couple of times, Jillian, to the sort of question of the constitutionality of this whole thing. And we all do constitutional law here, so we should give some attention to that. The basic question is, and the president's lawyers have fronted this in their papers thus far, is that kind of a jurisdictional argument that the Senate just has no jurisdiction to try a person who's former president, but now a private citizen on articles of impeachment. Can you lay out that argument for us and then give us your sense of it in terms of whether it's persuasive?
Sure, happy to. So the argument turns a lot on the text of Article 2, Section 4, which provides and says that the president's vice president and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. And then if you look at Article 1, Section 3, where there is the discussion of trying the president, there you have the identification that judgment shall not extend further than removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. And a lot of the arguments about whether or not the Senate has jurisdiction, I think, turn on how those two textual provisions work together. So the former president's lawyers argue that Article 2, which says that an official shall be removed from office, makes clear that removal is a constitutionally necessary outcome from an impeachment. If you can't remove from office, and you cannot remove a former president from office, then you can't impeach. And they see that part of the Constitution in Article 2 as qualifying the statement in Article 1, Section 3, that there are really two possible outcomes from impeachment: removal and disqualification. And even Article 1, Section 3, there are arguments that say disqualification is only meant to be supplementary. It's not meant to be an independent basis. My own view is that the better reading is that a former official can be tried on an impeachment. I think the text is compatible with that reading. I think that the structure and the history of impeachment support that. I would say, though, I don't think it's a slam dunk. I do think on this textual question, you can make an argument both ways about how these two pieces of text fit together. But it also depends on where you put the onus and the sort of burden of persuasion. So the former President Trump's lawyers say there's nothing in the Constitution that expressly says that a former official can be removed. And of course, the opposite view is, well, there's really nothing there that expressly says a former official can't be impeached. So part of it is weighing those two arguments against each other. When you turn to the history and the structure, so in terms of the structure, impeachment I see really essentially as a political check, and the availability of disqualification shows that it's meant to be both a preventative as well as in removing from office as also having a preventative but also a responsive aspect. And if the president could forestall disqualification by resigning before the impeachment trial, I think that preventative function and the overall political check of impeachment would be undermined. And criminal conviction isn't a substitute, it's still a gap. There are different, you can impeach on crimes that you can't, on high crimes and misdemeanors, and on actions that you can't criminally convict for. So I think it would undermine the structural check. And there is historical evidence which we can talk about early British and early American state constitutions having provision for impeachment, early British impeachment of former officials, both those cases. And you also have historical practice happening both initially and then particularly at the end of towards the end of the 19th century, at the beginning of the 20th, that support the idea of former officials. So I think that's the better view, but I do see how you can make an argument for the other side.
Welcome any other comments on this. Bob, I know you published an important op-ed on this very issue just in the last couple of weeks. Do you want to add anything to what Jillian has just laid out for us?
I thought Jillian outlined it very well. There's only one other point I'd stress, and there's a lot of dimensions to this argument that we can go over and debate. But as you read the answer that the Trump lawyers have filed, and then the retrial brief that they filed today, they continue to put a good deal of emphasis on how extraordinary it would be to visit this punishment on a private citizen, that disqualification would take place of a private citizen. Disqualification can never take place of anyone but a private citizen, because the president upon conviction becomes a private citizen immediately. And there is nothing in the Constitution that suggests that the Senate, for example, would have to take the vote on disqualification the same day as the vote on conviction, or the following day, or 2 to 3 weeks later. But one way or the other, a disqualified former executive branch official who had been impeached is always disqualified when a private citizen. So I don't find the argument that he's a private citizen, though I know it has some rhetorical power for the Trump lawyers. I don't think that's convincing or accurate, consistent with the text. I would mention, by the way, that in what had to have been, I don't know how much of a difference it's going to make, but it's somewhat of a break in the legal ranks on this point. Charles Cooper, who is a well-known Republican appellate lawyer, published an op-ed in the Wall Street Journal, who stressed just this point, that he did not believe that you could read the provision correctly to make it impossible to vote on the disqualification of a private citizen for just the reasons that I outlined.
I noted that Michael McConnell, the former judge and former member of the Chicago law faculty, and now at Stanford, of course, has taken a similar position, focusing in particular on the text and trying to, if one is inclined to wring as much possible meaning as can be wrung out of the text itself, he reaches a conclusion that, by my lights anyway, seemed pretty persuasive. There certainly is no textual ban on trying a president who was impeached while in office, but then where the trial happens afterwards. Sorry, Jillian.
No, I was just going to say, I mean, he makes a different textual argument than just the one that I mentioned, which is he emphasizes the language saying that the Senate shall try all impeachments, and emphasizes also the factor that Trump was president when he was impeached, making it a constitutionally valid impeachment, and then emphasizes the all afterwards. So it's an additional supportive argument.
Melissa, welcome your views on this issue, and then as well as perhaps the next, which is, are there any scenarios where the courts could end up being the vehicle to provide any answers to these questions? Those of us who teach constitutional law, we all teach the Judge Nixon case, where where criminally tried and convicted and sentenced and then impeached and then tried on those articles of impeachment in the Senate. Judge Nixon tried to challenge that Senate trial in the courts, and the Supreme Court ultimately held political question. Does that mean all of this is a political question? Any role for the court?
So it's a terrific question. We just did the Nixon case, the other Nixon case that you've referenced, in class last week. And I have a hypothetical coming up in class this coming week about the prospect of whether the court really could step in to determine the justiciability of this particular impeachment hearing by the Senate. I think, again, the question isn't just a straightforward question of constitutional law. I think it sort of comes down to the idea of whether or not the justiciability doctrines also function as avoidance doctrines for the court. So one scenario that you might contemplate is that, someone did file a lawsuit and it made its way to the Supreme Court to determine whether or not the impeachment of a former president is permissible. And the court just not wanting to get involved, citing to the Nixon case and using the political question doctrine as an off-ramp to completely avoid having to deal with that. You could also see potentially another avenue in which the court sort of takes its Marbury versus Madison charge to say what the law is and really weigh in on what the scope of the Constitution has to say and what the meaning of the impeachment clause is with regard to whether or not it applies to someone who has been a public official but is no longer, or at least at this point, is not a public official.
Great. Anyway, can we play it forward? Anyone else thoughts on other postures that might drag the courts into this, whether they want to be there or not? I think Melissa's point about, looking for off-ramps sounds right as for motivation. For example, I'm wondering, suppose that former President Trump were to maintain that that the Senate just has no jurisdiction to try him, and acts on that understanding by seeking office in 2024. And suppose he's put on the ballot in some states. Would the courts be able to invoke the political question doctrine at that point? Be able, ultimately the Supreme Court will do what 5 of its members decide it can do. But does that seem like a political question to any of you, or does that seem justiciable? Bob, I see you nodding your head, which means I'm going to call on you.
I was nodding my head at the complexity of the issue. I do think that in the case, I've thought about it the other way, by the way, which is a case in which a state denies Trump ballot access and he goes to the Supreme Court of the United States. That probably is a little bit easier for the court to dodge. But here you have a situation where the Senate has disqualified and all of a sudden Trump is on the ballot by the hand of a willing Secretary of State someplace. And nobody knows how it's going to get resolved unless the Supreme Court steps in. And I'd have to say, and I'll be candid and say I haven't thought it through from every dimension, so this is a very sort of crude first cut answer. I think, as in all cases where the court decides when to intervene, but still try to demonstrate that it's cabining the exercise of its authority in a particular delicate area, this is one where they might be tempted to intervene and try to find a way to explain that they're cabining. How they would do that, I couldn't say.
Precedent good for this day and train only, or something like that?
Yes, as in, for example, Bush versus Gore.
Right.
I jump in. I think that's right. I think that they would be more willing to come in and enforce in that context, in part because of the logic that they gave when they did not get involved in Nixon, right? So to the extent they say that the power to impeach is a sole power, a power to impeach, sole power of the House, power to convict and try, a sole power of the Senate, right? To give force to, you can make an argument that in order to actually give that meaning means that when those branches have made those determinations, a court can enforce them, as opposed to, as was being sought in Nixon, to come in on the matter before they're trying and challenge their very mechanism of acting in what they're considering to be the appropriate trial. So I think they could draw a distinction there, and their logic, if they wanted to adhere to it, would seem to support it.
Yeah, I must say that's my inclination too, that the logic of the political question determination seems to be that other institution's judgment is determinative of the matter. And so what the court would be saying is that it's inconsistent for that to be so, and for there to be an end run made around the Senate's determination that either that the president is disqualified from office or that he is qualified for office, to second guess in this manner. Before we should talk in a moment about how strong is this case, and more particular defenses beyond the jurisdictional defense that the president's lawyers have already indicated that they will raise and press. But just one further point on the jurisdictional one: if it were the case that a former president can be tried in circumstances like this, should we be worried that that opens the door to some kind of slippery slope, that that the year before a presidential election, given our incredibly deeply divided political environment, that parties will be trying to determine who the strongest candidates are on the other side, who have ever served publicly in ways that might subject them to the impeachment power, and try and impeach at that point, and then to see if they could get a like-minded Congress to convict, just in order to sort of clear the field of strong opponents in the presidential election. I mean, in this case, obviously the House impeached while the president was still in office, But would this precedent only go that far, or might it provide a precedent for impeaching and trying a former president, former vice president, former cabinet member, even from office many years later? Is that a concern to worry about? Ryan, what do you think?
Sure. So I think it is a concern to worry about, especially because if we had a conviction, it's not as though we would have a unanimous opinion as to what was the legal basis for that conviction. And well, we all agreed to, senators say we all agreed, or a supermajority of us agreed to one particular textual analysis, which is as long as the impeachment took place while the person was in office in the House, and then the Senate gets to trial impeachments, that's the reason. So it gets narrowed down to that being the precedent. So I do think that that is actually the stronger argument. If we were just talking about objective analyses of these arguments, not the constitutional one, which is, yes, the Constitution permits it, but is this the right, wise decision? And how should that power be exercised with great discretion? Because, not only the scenario that you articulate, but I think anybody who served as a former senior member of an administration and then is running for office, and it doesn't even have to be for the presidency, there's going to be revelations in the media about very potentially bad acts that they engaged in while they were in office. And does that not potentially provide for members of Congress to then gin up or say, well, we're going to at least have this person impeached, even if they're not finally convicted, and that is a stain on them. And it's not just of the opposite party. I could imagine that there would be people of the same party that would prefer to have a strong candidate in their primaries subject to that kind of situation. So that's it. I think it's a realistic concern, and I think that's where the debate should be had. And it shouldn't be taken lightly in that sense. But I would come down in favor eventually of saying, but in this situation, the stakes are just so much higher on the other side of the balance. But yes, a very realistic concern that should be taken and as a serious concern if raised that way.
Anyone else want to weigh in on that issue?
Yeah, if I could, I would worry that we have a pressure potentially building up if action does not take place in connection with an impeachment. And in my view, the impeachment article is focused on acts that, if the Senate ultimately, does decide to convict, it's hard for me to see that this is not alleging a high crime committed by former President Trump in office. So in other words, I don't think we're dealing here with, for example, the problem that haunted the Clinton impeachment, which was, whether or not this was sort of the weaponization of private conduct that really didn't bear on fitness to hold office. I think this clearly bears on the conduct of a president of the United States and, as the articles say, subverting and obstructing the tally of electoral votes. I worry that if in this context, on these particular facts, this turns out to be, loosely speaking, precedent for an acquittal. Let's say an acquittal occurs and that becomes precedent. That's both alarming, but it will also may build up pressure for this alternative approach that is being suggested under the 14th Amendment, which is that the Congress could enact a statute that would give them the opportunity outside the impeachment process to find that someone had engaged within the terms of the 14th Amendment in rebellion or insurrection, and then under the legislative enabling clause, their authorizing clause, could be disqualified from holding future office. I think that pressure will build for that, and I think that's actually more of a slippery slope than addressing this squarely where I think it ought to be addressed, which is within the impeachment process. And I think we're going to be, unfortunately, directing attention away from this to a much more serious potential problem if it goes from impeachment to the 14th Amendment context.
I agree with that. I also think there's there are a couple of different factors that play into my assessment of sort of the wisdom here. One is that there is this danger of machination sort of on both sides, right? So particularly if the reason for not going forward is a determination sort of on a categorical basis that a former official can't be impeached, that really opens the door as well for abuses on that front, right? Where you can sort of game the system late in term and really undermine checks. So that's got to be factored in, and that sort of, I think, necessarily pushes you towards what Ryan was saying, sort of in this case, like in some sense, I think it has to be a case by case assessment. The other thing I would say is that although obviously our current polarized world is seems particularly prone to dysfunctional behavior, we have had polarization in the past. Impeachment has not been something that has been able to occur with great abandon. And in particular, the kind of close majorities that we have in Congress make the idea of impeachment, taking something that could be done, sort of done wantonly, I think more dubious, right? You do have a 2/3 requirement in the Senate for a reason, and that's really a very important check. And at the point at which you can get 2/3 of senators in our current political environment, that means you're talking bipartisan. And that, I think, ends up being a potent protection.
Mm-hmm. Mm-hmm.
It is worth noting, though, that one of the reasons why we were talking about the possibility of impeachment becoming unduly politicized is because we have, in the space of just a year, 2 impeachments of the same president in circumstances that, to some, look like a kind of trolling or harassment of that president. And so there's a way in which this particular environment has sort of cultivated a narrative in which this isn't a check or oversight, it really is harassment. And it's worth thinking about what that looks like and how that plays out in the future too.
Which may go to something that we should talk about later. Just to put a marker down for it now, it seems like a lot of the prognostication is skeptical about whether there will be the 2/3 majority that Jillian's just mentioned for conviction. I mean, perhaps there will be, but there seems to be a good deal of skepticism about that. But at the same time, it seems likely at this point that there's liable to be significantly more votes for conviction on this article of impeachment than there was for the president. Boy, it was just almost exactly a year ago, right? I think it feels like a decade. But and if that majority is not big enough to reach the 2/3, then of course it doesn't affect the outcome technically speaking, but it may be worth wondering in the spirit of Melissa's point, whether that will affect the sort of broader understanding of what actually happened, what the Senate was engaged in. Before we get to that speculation about the meaning of any particular outcome though, let's set aside the jurisdictional argument and play the trial through. One of the next kinds of defenses it looks like will be raised is a kind of free speech or First Amendment style defense, that this would involve convicting the president for speech that, were he a private citizen and were he facing criminal jeopardy for it, he would have a First Amendment defense to, or at least might. What do we make of that argument, Melissa?
So again, there have been a lot of discussions among constitutional law scholars about whether or not the First Amendment would apply in circumstances such as this. Technically, the First Amendment is a restraint on government imposing on the freedom of private citizens. Does the president function as a private citizen when he is operating in the scope, or at least during his term of office? And do the First Amendment's protections apply in those circumstances? So that's one set of questions. A second set of questions would be, if you assume that the First Amendment applies as a defense, does it apply as a defense to arguably inciting unlawful conduct? And arguably, no. The Supreme Court has held that where statements direct individuals toward lawless conduct, like, they are not accorded First Amendment protection. So that might be a second line of defense. But the speech aspect of it also, I think, speaks not just to the First Amendment, but to sort of a criminal intent standard and mens rea. And I think one of the defenses the president has put forth is that when he made those statements on January 6th at the rally, he was not speaking literally. He did not intend for them to go to the Capitol and take back their country, but really was speaking figuratively. And that could raise both First Amendment questions, but it could also raise more basic questions about state of mind and intent that just sort of go to mens rea. And again, this is not an ordinary criminal trial. It's kind of a sort of hybrid political legal trial. And you don't necessarily have to prove things in the same way that you would in an ordinary criminal proceeding, but it does speak to this question of intent. And I think that's actually one of the more promising defenses that the president has.
So that's helpful. On the prosecution side, Bob, how to take this one? So one is you could, and I don't mean to be too pejorative in showing my own cards here, but one is you could take the bait. That is, you could respond to the argument that if this were a criminal charge, that it wouldn't meet the elements, either in terms of mens rea, or it couldn't overcome a First Amendment immunity to engage in certain kind of speech. Another approach would be to say, this is not a criminal case, this is not a criminal charge, and so limits, both in terms of requirements of satisfying certain elements and First Amendment-based immunity, don't necessarily apply here. Which do we expect the prosecution to do as between those, or do we think they'll come to a fork in the road and take it and argue both sides? What do you anticipate?
I haven't read their most recent answer, which I think was filed today. It'd be hard to imagine that they wouldn't do what lawyers are always counseled to do, which is to answer each and every single one of the arguments that's put forward. Now, there is, I agree with you, a little bit of a trapdoor there, because you can get into an argument about what inciting speech is under the Brandsburg test, the applicable test for determining when the speech is really inciting speech as opposed to protected speech. And that does take you outside of what I think are the really charged constitutional dimensions of this case. The notion that somehow the president can speak with full protection from the impeachment process the way any private citizen could speak, that he could give a speech, for example, and this is, by the way, I think covered in the original trial brief filed by the House managers. The president could deliver a speech to the nation in which he avows that he holds racist views and that he will apply them whenever he possibly can. He puts white supremacist symbols in the background, so it's very clear that he means what he says. One could go on with all sorts of ways in which the words of a president just simply matter in this context, or let's put it this way, subject the president to responsibilities and obligations in this context that are not imposed on a private citizen. And I think it's an extraordinary proposition to hold otherwise. It gets back to whether or not the framers who were so concerned about demagogues, they were so concerned about those who would acquire office for their own purposes and would lie and seek to sow division with their lies, somehow didn't imagine that the impeachment process was available to protect against the outcome in the presidency that they were most worried about. And that outcome is an outcome that heavily relies upon the misuse of speech, and that I think is singularly associated with obligations that presidents carry that have, constitutional consequences like, impeachment, removal, and disqualification. Of all of the jurisdictional argument, it seems to me is one, just by contrast, I'll say this very quickly. The jurisdictional argument is one that, as Jillian pointed out, somebody can make a reasonable case for. I happen to think it's flawed, but they can make a reasonable case. I find the First Amendment argument just alarmingly misguided. And I do hope that the Senate goes ahead and takes it sort of on directly, rather than be sort of guided into all sorts of arguments about what exactly did he say and how does that really measure up to the standards for a criminal defense. I think that's a very dangerous route to go.
Seems an extremely important point. Everyone I know has been thinking of their own hypothetical along those lines of the sort of, avowed racism you just gave. I was thinking, suppose a president just announces an intention to disclose all national security information to Russia. He hasn't done it yet. He hasn't taken any steps yet. He hasn't conspired with anyone to do it. The notion that we'd have to wait around for the president to do those things, all of which are crimes, as opposed to act on the publicly avowed intent to do that, would be to render impeachment a pretty ineffective remedy against the precise thing. So now I've shown my cards. I agree with Bob on this one. Before the next question, we've reached sufficient point for me to tell all of you wanting to receive CLE credit about the code. Here's the code. It is RCLS 2371. There it is. RCLS 2371. write that down. And then when you get your email from the CLE powers that be, there will be a place for you to list that code. Okay, I think we can return to business. So do we know at this point about any additional defenses to anticipate from the president's team? We've talked about a general jurisdictional one. We've talked about a kind of First Amendment based immunity for certain kinds of speech. Anything else we expect to hear from them at this point? I'll leave that to anyone who has any thoughts on that.
They have a bill of attainder argument that they have floated.
Tell us about that.
Well, I have to say I'm not entirely sure. As I understand the argument, it would be that the impeachment trial is a bill of attainder because it is singling out the president for a punishment, particularly the punishment of disqualification. What seems odd about this is it seems inherently to me dependent on the prior claim that there's no jurisdiction. Because if there's jurisdiction and you can impeach, then it can't be the case that impeachment, which is expressly provided for in the Constitution, resulting in removal and possibly disqualification, could be a bill of attainder, because you would be eviscerating one part of the Constitution with the text of the other. So that can't be right. Even separate from the sort of the hijacking on that initial jurisdictional claim, an impeachment trial it's not a bill, it's a trial. That's what the Senate is doing. It is trying impeachment. And a bill of attainder really is this idea of Congress passing legislation that is singling out one individual for a particular punishment. I think that the invocation of the president as a private individual is partially connected to this bill of attainder idea, although I haven't read their papers carefully enough to fully know that. But that gets at this idea that you've got this private person who is being singled out in an abuse of governmental power. But again, that assumes the former president is just a private individual, and also assumes that a trial could fall under the bill of attainder prohibition.
There's also another defense that proceeds from the point I made earlier about the article of impeachment being sort of broad in terms of the narrative underlying the insurrection. And so one defense that the president's lawyers has raised is that it was a hastily drafted article of impeachment, and in being sort of put together in this kind of slipshod way, it was impermissibly duplicitous, which is to say that it sort of masses together all of these different episodes and bits of conduct that could individually have been independent charges or bases for impeachment. And that is meaningful and should lead to an acquittal, because if 2/3 of the Senate is required to convict, they actually have to be required to convict as to that particular charge that was charged in the article of impeachment. So if there are all of these other kinds of charges in the single article of impeachment, you can't really be certain as to what the 2/3 conviction vote is on. And for that reason, it would be impermissible if conviction were actually to be obtained.
So this is sort of like the impeachment version of a single subject rule or something? Like you just, in any given impeachment article, you can only address one high crime or misdemeanor at a time or something like that?
That seems exactly right. And in fact, there's a footnote in their memo where they cite to Charles Allen Wright's Federal Practice and Procedure about this idea that there can only be one single count per charge, and that this is massing them together makes it harder to sort of suss out exactly what the vote for impeachment is on or conviction is on.
Seems to suggest that there might be an incentive that if you've engaged in high crimes and misdemeanors, do a bunch more of them in short order, and it might make it harder for you to be convicted on any of them. Bob, I wanted to let you in. I don't know if you had anything to add here. The bill of attainder argument, as Jillian laid out, does seem to be just a rerun of the argument you were addressing before in terms of private citizen. Yeah, otherwise, the bill of attainder prohibition would itself nullify the impeachment and removal from office mechanism.
Yes, for those reasons, and for those reasons that and the others that Jillian cited, I think this one is extraordinarily weak. I mean, I just don't see how it flies. That's not to say the senators can't decide that it flies, because they can decide whatever they want. Let me just mention real quickly two other pieces. One is the suggestion that there were due process violations here. If you recall, in the Ukraine impeachment, the White House counsel put an enormous amount of emphasis on the denial of due process. And so there's a question here of, to what procedural protections are presidents guaranteed in the impeachment process? And one of their arguments is that the House rushed it, and they rushed it and therefore didn't do the requisite factual investigation. But the other point I wanted to raise as well is they're also disputing the factual allegations about the president's attempt to subvert and to obstruct the certification of the electoral votes. They're saying he didn't say what the House said they did. In fact, in the most recent pretrial brief, I believe the lawyers come straight out and say that Nancy Pelosi, the House, is essentially deceiving people, and that Pelosi has lied about his conduct, that he was concerned generally with election security, which is, by the way, another piece of their free speech argument. Why shouldn't anybody be able to express an opinion on election security? And as a president, presumably, he'd be concerned with election security, but that he wasn't not only not inciting violence, but they walk away from the suggestion and refuse to repeat or engage with the suggestion, or not the suggestion, the record, that both on that occasion and in the period leading up to that occasion, he told the country and the people at the rally and his supporters that the election had been stolen, had been absolutely stolen. It had been taken away from him, though he had won by a landslide, and had been taken away from him by various fraudulent acts that he repeated, all of them rejected by the courts, some of them very specifically put before the courts and tested factually and rejected. And they are walking away from that and saying that, in effect, characterizing his comments on January 6th in isolation and refusing to actually acknowledge and come to terms with the specific charges that he was making. That's part and parcel of we now know how some of the people in the rally thought about the reasons why they needed to go charge the Capitol.
Wow. So if I've heard you right, they are denying that Trump, in the period between the election and January 6th, claimed that the election had been stolen?
Yes, the language they use, they are saying it's a denial by implication. They're saying that he was exercising his free speech rights to express concerns about election security, about voting irregularities generally, that's completely reasonable. They are not repeating, because they know the Republican caucus doesn't want them to repeat, that it was his opinion and he was entitled to express his opinion that massive fraud had been perpetrated to take the presidency away from him. So they stay away from all of those claims, which are, of course, at the heart of the attempt to subvert and obstruct the counting of the electoral votes. They say nothing, for example, also about his claims about Mike Pence's, former Vice President Pence's, constitutional authority to turn the results back to the states. They say nothing, for example, about his claim at the rally that some of the swing states had renounced their previous certifications and were waiting for the opportunity to correct them, all of them which were falsehoods. They walk away from all of that. They don't want to engage with that at all. And that's where they're left, with these generalized averments that he was concerned with election security generally.
This connects in some ways to an interesting feature, I think, about the article of impeachment. So you have the violence, incitement to violence, and you do have reference to Trump violating the oath to preserve, protect, and defend the Constitution of the United States in leading up to that as a result. But that's not a separate claim of its own as a separate article. And they're obviously overlapping. You can easily see why you would just build it into one and keep it simple. But part of what is so scandalous and damaging and demagoguery about what Trump did was that he did precisely that. It's not just the violence and the insurrection on the day of the counting on January 6th. It's all of the effort to undermine the core principle of peaceful transfer of power and of the election and respecting the majority's choice. And the facts that they put in bring it in, but it's not given the same kind of showcase that it potentially could have been. These
kind of fact-focused defenses that particularly the ones that Bob was just running through for us, seemed like they raised a sort of interesting question for the House managers, for the prosecution side. I mean, the last time round with the last impeachment trial, the votes against conviction seemed to kind of coalesce into some different camps. One was, we just don't think, the president actually did the things that are being alleged. Another was, okay, he did those things, but they're not impeachable, not high crimes and misdemeanors, or even, I guess a third might be, even if they technically are, as a prudential matter, we shouldn't convict in these circumstances. I think in one way or another, each of you has sort of reverted to this. Given what is being alleged here and the video-based evidence that is going to be put on, well, no, set aside the evidence, just what is being alleged here, it seems more challenging if you were inclined to vote against conviction to try and occupy the space. Okay, yes, he did all of these things that he's alleged to have done. Factually, what the House managers are alleging is all true, but I just don't think it's appropriate to convict. I just don't think it's a high crime or misdemeanor to, incite an insurrection. Set aside the jurisdictional argument. On the facts, that seems hard to maintain. And so that presents a question, I guess. Will there be an opportunity for the House managers to try and say to Trump's lawyers, if they're going to be the ones answering questions, I guess, or to anyone else, we understand that you don't quite want to admit all the things that we're alleging, but if those things were true, would that be an appropriate occasion to impeach and convict a president? That seems like a more fruitful line of argument this time around, perhaps, than last, or not. I guess I mean that as a question. What do y'all think? Ryan, I'll start with you.
So I definitely think that's correct. I actually did a tally of how many Senate Republicans last time said exactly what you just described, Trevor, which is the House managers proved their case factually, but I don't see this as rising to the occasion of impeachable conduct or that he should be impeached for it.
Right.
And I actually thought that was remarkable for the historical record, that we understand there was in fact a bipartisan vote on the part of the Senate,
On the
at least
facts.
saying that on the facts, and not just Mitt Romney, but a handful of others. And I agree with you. I think there are going to be multiple opportunities for this, including when the senators get to ask their question in writing to Trump's lawyers. And it's the only way in which I think I also agree with you that they can really answer it is by actually fighting the question and saying, well, no, factually, that's just not what occurred. And, what Melissa had mentioned earlier, which is he was speaking figuratively that day. He had no intention for this to happen. And he acted with dispatch to try to stop what he saw happening. So that they're contesting the facts. I think that's where they need to be. And because of once they lose on the facts, it seems so difficult. So the out for the Senate, so those Senate Republicans who don't want to vote for conviction is to say, he engaged in these acts, but I can't do it because of the constitutional jurisdictional question. And so that's why it's not impeachable in that way. So don't reach it for that purpose. But yes, I agree that they proved, and then they don't need to even specify exactly what that particular senator thinks that the House managers proved, because they don't really reach that question on conviction or acquittal.
Others on this, how do we expect the sort of laying out of the facts to happen? Is it just going to be by this video evidence and sort of who are you going to believe, him or your lying eyes thing, or how do we expect that narrative to be built over time?
So let me jump in because I have to jump off and find out how I can get into high school in a few minutes.
Right. Yeah. Liz has to leave early tonight. Yeah.
It's a good point, though, to reference that impeachment is at once a trial a case is being made to the senators who themselves were witnesses to what happened on January 6th. So there's that aspect of it. But given the nature of the Senate, given the unlikelihood of a conviction here, there's also this other sort of demos prudential kind of function here where the House managers are actually making a broader case to the public. And that may be perhaps the more important function of at least this impeachment trial, and sort of making clear the stakes more generally to the American people. So some of that, I think, will come from the video evidence that's being compiled by the same company that put together the video presentations that were used in the last impeachment. I think this will probably be more impactful, just given the nature of the events, but those will unfold. And then, I'm not sure that they'll have witnesses. I think there's a lot of pressure to make this as short and sweet as possible, but I imagine just the footage itself, which we all may have seen some part of, but probably haven't seen seriatim over just sort of how the whole day progressed, could be incredibly searing and visceral, and sort of, allow the public to re-engage with the events of January 6th in a more pronounced way. So thanks for having me. I'm going to go get into high school right now.
Yeah.
See you
Good
later.
luck with high school.
Thank
It's a nice segue onto the last general topic I hope we could cover tonight, which is sort of projecting now to the outcome before the trial's ever really begun. But if the result is something like a majority, but not the required 2/3 majority of senators vote to convict, what do you all expect the effect in the country of that to be? I mean, to ask that in sort of as open-ended a way as I can, politically, socially, ideologically, in terms of domestic terrorism and extremism. Should we be more or less worried about those risks going forward? What's going to be the impact on the country if the outcome is one that does not categorically disqualify the president from future public service, the former president from future public service, but that does show that there was some kind of bipartisanship in a vote to convict on this article? Ryan, go ahead. You start us. Yeah.
So I think of it in similar terms in the way I think that there's a formal question as to whether or not there'll be a vote for conviction, so that the former president will be disqualified as a matter of law from ever being able to run for office again. And then there's the informal process, which is the court of public opinion, as Melissa just mentioned, and the more general question of whether or not this person should be disqualified by many parts of our society from being in the public square, and from being able to potentially even run for office again. And I think that's what this trial sets up. It's that general idea of, was he in fact convicted? Were there in fact a supermajority potential of the Senate that agreed he did it? And it's a utter affront to our constitutional democracy what he did. And he represents that level of a threat to the democratic process. And there, I think you do indeed have much broader support within the Republican Party. I do think that's Mitch McConnell's agenda. He does not want Donald Trump to define the Republican Party. He's trying to save the Republican Party from Donald Trump. And so the court of public opinion and that form of conviction by the Senate, with statements that they will be able to make, I think might in fact set the narrative, our understanding of history and our understanding of the contemporary threat that we face.
Great. Jillian, what do you think?
Yeah, I think that's right. I mean, it's interesting. In some sense, it's a kind of constitutional compromise, not necessarily intended, but one where the Senate can make clear and sort of affirm the facts of what happened for the historical record and for the popular view, and avoid the more draconian move, which, although I think it's appropriate, is more draconian, of actually going as far as convicting. So you can get some condemnation more than a censure, in the sense, even though there isn't the outcome of the censure or the outcome of disqualification, the vote itself, I think, has a kind of public resonance that can allow a certain kind of distancing without necessarily the sort of hard edge of disqualification. I think the real question will come up, though, in the future when, if President Trump does try to run again, and that would then, I think, tee up some of the issues that you could think could be dealt with by majority, but not supermajority. That you wouldn't be able to avoid it in the future. What about the fact that a majority of the Senate, and I would think a substantial majority of the country feel like he did engage in this and probably therefore should be disqualified. The other thing that I think is interesting in terms of your question about how does it play in terms of domestic terrorism is that the arguments that Trump needs to make in order to deny the facts and deny the claim, to some extent, are basically putting his followers, throwing them under the bus. In that, and you see this in the brief that was filed today. It was a group of people who acted unlawfully. It should all be condemned. That what they did was terrible, but it wasn't President Trump who urged it. And we already have seen some degree of pulling back from him, from his response of not eventually, finally, not sanctioning what occurred. And I wonder whether actually, more of this kind of argument from his lawyers in the Senate may further isolate him from that part of his base that has been as strong. So he may not have that motivating stature that he has, but those forces will still remain, unfortunately, very strong as they are now. But he may get a little bit more disassociated from them, or at least that's an optimistic take.
That's interesting. Bob, what do you think?
I have a darker view of what an acquittal would mean. I think it's going to be an acquittal. I think it would obviously better that a majority of the Senate go on record here. But I think that in the media world that we live in, the ability of the other side to present this as yet the second time that the Democrats tried to bring Donald Trump down, and some, how would you call them, misguided, if not treacherous, Republicans who voted with him, that it is going to feed into what I think Trump's politics really prize, which is a narrative of both victimization and of continuously having to fight off elite forces that don't speak for the American people the way that he does, and therefore are trying to undermine him. And I think it's going to be I think the headline will be Trump acquitted. That will be the headline he holds up. That will be what I think he and his people would build on to make the case that, he's sort of the president who you sort of like in those horror films where, the nuclear weaponry actually makes the monster stronger, right? That it just keeps on absorbing this extraordinary power and then reflecting it back on its adversaries. So I think that is a likely political outcome. Now, of course, the course of the trial and anything he says over the course of the trial, there are some unknowns here. So I don't want to suggest that everything that we know today is what we're going to think back on as having had during the trial. The only other point I would make is I do understand, and I think it's a fair point, that Gillian notes that he's throwing his supporters under the bus. The pretrial brief that was filed talks about, these people who did horrible things, and everybody can agree they're horrific. But I think his supporters are kind of in on that. I think they know they think, well, he has to say that. He has to say that to dig himself out and to defend himself against these people who are continuously persecuting him. So I do not think it's a good outcome, even if most people think there's no 17 votes to make the outcome any different. I think it's a very dangerous constitutional moment. The notion that the conduct that we saw from November 3rd to January 6th, through January 6th and beyond, by the way, I might add, that is somehow conduct that the Senate concluded was not impeachable. Now, granted, the jurisdictional argument will give them a little bit of cover on that. Well, it wasn't constitutional, as much as we are horrified by it. But I think that it will be a most unfortunate constitutional moment.
It does seem hard to escape the conclusion that surely Trump will claim that he won, right? I don't even know that he'll use the language of acquitted. I think he'll say, we won. Yes. Vindication. I won this thing.
Yes, absolutely. In the election, which was stolen from me, I was twice defeated. They twice tried to bring me down by impeachment. The only thing they have left is a stolen election, and I'm going to carry on my fight to get that recognized.
Yeah, we'll fix that in 4 years. And in the meantime, he'll be in a political position, I would imagine, to fund pretty powerful primaries against any of those Republicans who did vote to convict and who are up for re-election and who seek it in 2022. Whereas if we somehow got over the 2/3 threshold, setting aside whether he runs himself again, I'm just not sure he controls political levers in the same way if there's that supermajority, which is to return to Ryan's point. Like if the party leaders in fact think it's bad for the party, that's not the reason you're supposed to vote to convict on impeachment, but on an otherwise, available vote.
Mhm.
One wonders whether they'll see it that way. Now, at this point, I don't know that any of us, I'm not going to ask any of you to actually, give me odds on what outcome you predict, but I don't hear anyone thinking it's likely that we will see a 2/3 majority vote in the Senate. So it remains to be seen. It remains to be watched. Thank you to all of you for joining us tonight. Thanks to the 600+ participants who joined us here for this webinar. And thanks especially to Jillian, to Ryan, and to Bob, and to Melissa for sharing your insights on all of this. Final words from any of you?
Thank you. I enjoyed the discussion.
Great.
Same here.
Thank you. And thanks again to all of you for joining us, and stay tuned for more from NYU Law. Thanks.